Right. Thank you, Christina. Um, Appreciate your introduction, and I hope I can live up to the billing. One thing that and can you hear me okay? Give me a nod. Hear me okay? I'm going to apologize ahead of time. I have actually two business partners, and I'm working from my home office, and I have two business partners. One is a Black Labrador Retriever, and he is in his crate, so I have him under control this morning. And they visit from time to time. The other is an orange tabby cat. And for those of you who have cats, you know that there's only so much you can do with a cat. And so he may try to come and visit, and if he does, I apologize in advance for the disruption. But the session today, we're going to spend most of our time talking about employment law. And we're going to try not to get down into the weeds too deeply for the sake of time. And it is complicated. And so I'm not going to pretend to be an attorney today, but I have worked with a lot of them, and I've dealt with these type of matters over 25 years. So I've got a little bit of experience that may be helpful to you. Next week, we're going to talk about hiring and discipline and firing. And of the two sessions, that will be the most exciting. So we'll get what I call the boring stuff over with this morning, and then next week we'll have a little bit more fun. Before I begin, I want to give special thanks to Brown Edwards CPAs. They are a sponsor of this presentation, as well as Cowan Perry. And Cowan Perry, they're a law firm that actually Jim Cowan in particular reviewed my notes to make sure that I wasn't telling you incorrectly on some things. So we want to thank both of those sponsors for their help today. So I don't know if there are any golfers in the group. And if there are golfers in the group, this graphic will make sense to you. You have a lot of things that you could be thinking about when you go to hit a golf ball. And if you think about too many things at one time, you can't even swing the golf club. So the idea behind that is you have to focus on a couple of things. I don't know if you've seen this graphic or not, but I actually saw this even at the Homestead one time, even where really good golfers play golf. And they know that sometimes you can have too many things on your mind and it can create a problem for you. And likewise with what we're doing today, you can't do it all, or at least not at once, or you freeze over, like a golfer freezes over the golf ball and can't swing the club if they have too many things on their mind. Likewise, you won't be able to execute as far as your employment basics. Not all laws are going to apply to you. As a matter of fact, most of them will not apply to you because you are smaller employers. But I think that there is merit in following the spirit of the law. Most laws are written with good intentions. And then you know what happens with good intentions. So, but there is merit in following the spirit of the law. And then there are some state laws that actually apply to smaller employers. But the majority of the laws that we're going to be dealing with today are federal law, right? Because Virginia doesn't have certain employment laws that the federal law, and so they defer to the federal laws. Okay, they can be complicated and they can be situational, and life is complicated, and each situation is a little different. So it's very difficult to just put these type of matters in a box and create a cookie cutter approach, because again, situations differ. I want to encourage you at times, and you have to use your best judgment for that. You will need to seek legal advice, and sometimes, we don't like having to pay attorneys any more than we have to, but sometimes they're of great value. And so use good judgment and seek legal advice when you need to. We're not going to cover them all just for the sake of time, can't possibly do that. But I'm going to try to cover the major federal laws in the order in which they became law. And there's an overarching principle that I think that you need to keep in mind. Keep in mind what's good for the business. Ask yourself that question as you approach HR matters in general. What is good for the business? And oftentimes, if you can do that objectively, then you can generally stay out of the weeds. And also, consistency is really important. I will talk a little bit more about that when I talk about drug screening in a little bit, how important consistency is. So we will begin with the Fair Labor Standards Act. And it became law in 1938. And that was a long time ago. And it is still law. And it's a federal law. It's often referred to as wage and hour law. And by the way, before we go any further, if you have questions during the presentation, please unmute, say something, and we'll address that question then so we don't forget at the end. Okay, but there will be time at the end as well for questions. But the Fair Labor Standards Act is often referred to as the wage and hour law. There is no minimum employer size for that. So there are some exceptions for agricultural jobs, certain industries, but from all indications, it applies to you and to your company. So it sets a federal minimum wage. The federal minimum wage still is $7.25 an hour. All right, but Virginia has a minimum wage that trumps that. Right now it's $11, and it's going to go to $12 an hour as of January the 1st, 2023. Now, when we say, well, it sets a minimum wage of $7.25, I doubt seriously if you were able to find employees today at that minimum wage. My experience has been most employers are having to pay significantly more than that to get people to come on board. But anyway, but the Virginia minimum wage is $11 right now. The Fair Labor Standards Act, it requires you to pay time and a half for hours worked over 40 in an established work week. So there are a couple of important things there for you to know. First of all, you got to establish a work week. And so what is that? Most people say it's from midnight on Sunday, or 12:01 a.m. on Sunday through 11:59 p.m. on Saturday, all right, or something like that. And they establish Sunday through Saturday as being their work week. Establish a work week. And it says during that, and another operative word in that sentence, 40 hours worked. So if a person receives vacation time, that does not have to go into the calculation for time and a half, right? So, but if a person works 40 hours or over 40 hours, they need to get paid time and a half, unless those people are exempt employees. And to be an exempt, and that means exempt from the overtime provisions, right? To be an exempt employee, you have to meet a couple criteria. You have to be paid a fixed salary of at least $684 a week. And you must work in a position that passes a duties test. And that's where it gets complicated, right? Because that duties test, it's a lot of subjectivity into that, and objectivity too. And it can get really complicated. And so most of the time we can say, all right, a custodian working for a company would be a non-exempt employee and is paid by the hour. Most of the time, or oftentimes, especially with larger employers, we can say the chief executive officer of that company is an exempt employee because of their management responsibility and because of their pay, that type of thing. But somewhere in the middle, then you get to a line in which it's difficult to determine whether a person is exempt or non-exempt. And that's where employers have some difficulty. There's a fact sheet that I have the link here, and you can go out, and it is a very good fact sheet on the Department of Labor website. And it will tell you what the duties test looks like, and it walks you through the criteria. But just a bit of advice, when in doubt, if you get close to that line and you're not sure if a person is exempt or non-exempt, if you have that issue, pay that person hourly. Because you can't run afoul if you pay the person hourly. Yes, you're going to have to pay time and a half if they work over 40, but you can pay them hourly and be safe, not running up against or not violating the exemption rule. Does that make sense? Okay, so when in doubt, pay hourly. The Fair Labor Standards Act also establishes certain child labor standards. 18 years of age for hazardous work. Person has to be 18 years old or older. Breaks are not required in Virginia. People ask me that often. Breaks are not required in Virginia if the person's over 15 years old. So, but again, what's good, if you go back to what's good for the business, right? And answer that question, is it good to give folks a break so that you can, improve or have good employee morale, that type of thing. The Fair Labor Standards Act was amended in 1963 by the Equal Pay Act, and it covers all employers covered under the Fair Labor Standards Act, and it prohibits wage discrimination based on sex. And that's what the Equal Pay Act does. This is the Civil Rights Act of 1964, and it's actually Title VII of the Civil Rights Act, and that's what really establishes the law related to discrimination or anti-discrimination relative to race, national origin, sex, and religion. There were civil rights laws prior to that. Actually, there's a civil rights law of 1866, right after the Civil War. But really, we know that some of those laws, knowing what happened during Jim Crow and all that, didn't really have much of an effect. But the Civil Rights Act of 1964 is a major civil rights law. It's federal law. Again, it applies to employers with 15 or more employees. The Virginia Values Act extends similar protections to smaller employees. If an employer has 6 or more employees, they can bring a claim that's similar to a Title VII claim if they feel like they were wrongfully discharged. All right, but you cannot discriminate against an employee or prospect based on race, color, national origin, sex, or religion. It was amended in 1978 to cover pregnancy, and it treated pregnancy, or a lot of times women, in particular pregnant women, were discriminated against from an employment standpoint, and now it treats this as a form of sex discrimination. So you treat pregnancy the same as you treat any other temporary disability. All right. I remember a time in which employers would ask women questions like, were you thinking about getting pregnant? Don't ask that question. All right. But that was commonplace many years ago. People, because in an employer's mind, well, I've got to understand, if I'm going to have to cover that position, if this lady is out on maternity leave, that type of thing. Well, we generally don't ask people questions like, are you going to become temporary disabled for this reason or that? So you treat it just like any other disability or temporary disability. It was amended in 1991 to include a prohibition against sexual harassment. And there are 2 types of sexual harassment. One is very blatant, and that's quid pro quo. And quid pro quo means this for that. And so someone could say, if you do this, I will give you that. In other words, you do this sexual act for me, and I'll give you this promotion. That's what this for that means. And sexual harassment can, we generally think of men toward women, but that's not the case. Not always the case. So please keep that in mind. And then there's also hostile work environment. In hostile work environment, my caution there is just to maintain a level of professionalism within the work environment. Because what's reasonable to somebody may be hostile to someone else. And so the things that we're talking about here, inappropriate jokes, inappropriate posters, or those type of things that may be in an office or used to be in an office, those type, just try to maintain a professional work environment. And it's a best practice to follow, even though most of you are not covered technically under Title VII. Who wants to discriminate today? And so, who does that? I mean, so the idea is it's a best practice to follow, even though you may not be technically covered under. The Age Discrimination in Employment Act, ADEA, that was 1967. Again, that's federal law. And it applies to employers with 20 or more employees. And it protects folks like me. It protects folks that are 40 or older. All right. And it protects whether they're an employee or whether they're an applicant, 40 years of age or greater, from discrimination based on age. So you can't force an employee to retire, for instance, because they're approaching a certain age. There are some exceptions to that, but generally there are compensation exceptions for like a partner in a certain type of firm. And they have to be able to get this much compensation in retirement. It's complicated. It really doesn't apply to most employers. Don't assume a person can't do a job because of their age. I know a company that now has a lot of drivers, that shuttle drivers, and the vast majority of those shuttle drivers are retirees. And they are the most dependable employees that they have. They show up every day, they come to work, they're at work early, they're ready, that type of thing. So don't assume just because a person is older that they can't do a job. Physical may be appropriate after you make an offer. That's good legal advice. After you make an offer to somebody, you can have a person do a physical to make sure that they are physically able to do the job, but don't pick and choose. Like, well, I'll have this older guy go for a physical, but this younger guy, he's okay, I won't have him go for the physical. So again, that consistency is important. An appropriate question: if you don't use an application for employment, even if you employ 2 or 3 people, I would encourage you to have an application. And because it's just, there are questions on the application. If you have a standard application, you can go online and find one, a freebie out there that most of them are pretty good. And but print you out an application, have people complete an application. And one of the questions that should be on the application is, you don't ask people how old they are, but you ask them, are you 18 years old or older? Because again, that goes back to you can't employ folks in a hazardous position if they are under 18. So you can ask them the question, are you 18 or older? So I can employ you in a hazardous position type of question. And again, it's a best practice to follow. And I've already talked about the employer that has a lot of drivers that are older drivers, and they're excellent drivers. The next law is something you are probably much more familiar with than I am, but it's the Occupational Safety and Health Act, OSHA Act of 1970. And it is federal law, and there's no minimum employer size. And you're familiar with, there's a general duty clause, and each employer in it, there's a list of items that you must do. I just put in a couple. Must provide a workplace free of hazards, and you must comply with the standards of the act. And likewise, each employee must comply with the OSHA standards. The standards are very strict. There are different standards by industry, but the importance remains the same. And so, you must provide safe equipment. You must provide training for certain equipment. Only certified people can operate that equipment. Drug and alcohol-free workplace. We're going to talk about drug screening here in just a minute. It protects whistleblowers, people that say, hey, this is an unsafe act. You must alert employees of their rights, and you can't ask employees to break the standards. So, and again, OSHA can be seen as a pain, and I understand that. But in some cases, you go, oh, gosh, these are overly laborious things that we have to do. But providing a safe workplace is moral, it's an ethical responsibility as well as a legal responsibility. And I will tell you that better run companies have better safety programs. My experience has been that they go hand in hand. And I know if you have issues, your insurance, as far as what to do, I'm sure your insurance providers oftentimes give you a lot of insight and information as to what is a strong safety program. And it can help you. Everybody has a right, I don't say that lightly, to go home at the end of the day, more tired, but all their fingers, all their toes, they have a right to go home and at the end of the day. So having a strong safety program helps ensure that. And from a cost standpoint, we know how much injuries, what injuries can cost. The drug-free and alcohol-free, and I thought I'd spend a little bit of time on this because there's a lot of discussion about it. You know that a small amount of marijuana has been decriminalized in Virginia. But if you look back at the general duty clause of OSHA, you've got to provide a safe workplace. And there are studies that show that people that abuse drugs, and marijuana is one of them, they have attendance problems and they are less safe. So there's the vast majority of employers are still testing, and they are still testing for marijuana. All right. And a lot of employers are doing pre-employment, random, post-accident, and reasonable suspicion. And I think that where we're going is employers are going to have to become better at identifying, having reasonable suspicion and having a process in place for that. I think that's where we're going. And now, primarily, I talked with a provider yesterday, as a matter of fact, they're doing urinalysis and some are doing hair, the analyzing the hair. The breathalyzer is coming for marijuana, and actually it's in place now. That the same type of instrument that we've been able to use on alcohol for a number of years is coming for marijuana, and it's available, but the states need to determine what under the influence, the percentage, like it's, I think, 0.08 for alcohol, and the states are going to have to determine what that percentage is for marijuana. All right. So when that breathalyzer comes, I think that will make things, and is available, and we know what the rules are. I think that will make things better, but it's still coming. Whether it's been decriminalized or not, a person cannot be impaired on the job. And that goes for under the influence of marijuana or any other drug, under the influence of alcohol. They cannot be impaired on the job. So I think reasonable cause training is a good investment. Oftentimes the service providers that provide your drug screens will do that. And I think that it's just a good thing for your supervisors in particular to know. It's not just about catching somebody. It's about, you don't want an unsafe person on the job site, but you don't want them on the job site for their benefit as well. And so as difficult as it is sometimes to look at somebody and say, hey, I need to take you aside here, I need to talk with you a minute and discuss that you feel like that they are under the influence. As difficult as that may be sometimes, that's better than letting them go on to work and get hurt. And so I encourage you to build that into your process and into kind of your culture. All right. And consistency is key here. So, if your brother-in-law shows up one day and you think he's under the influence, you need to treat your brother-in-law the same way as you treat any other employee. And again, if you're consistent in that, then that helps keep you out of trouble. And so consistency is key. Any questions so far? Everybody good right now? Okay. even though there are those who dispute that we have a southern border. And if you watch the news, you wonder what's going on and with all of that. We still have, as employers, we still have responsibilities under the Immigration Reform and Control Act of 1986, RCA, and it's federal law, and it applies to all employers. And you can't hire or employ an individual who is not authorized with respect to employment. All right. And you must verify their identity and their employment authorization on the Form I-9. And so a best practice for this is to complete the I-9 on the date of hire. All right. The employee needs to complete that on the date of hire, but you have up to, I think it's 3 days to complete. Well, don't wait. And here's why. I have seen this happen. They wait to complete it, and Joe goes out on the job, and the job's 25 miles away, and Joe's out there, but wait a minute, there's something not right here. I can't get this verified. And then there's a problem, and then all of a sudden your field supervisor loves Joe and hates you because you're pulling Joe off the job. And the best thing to do is to verify their employment eligibility day one, and do that. And those of you who complete these I-9s, you know that there are instructions, and those instructions will give you, you can take one item from a list A, and then one item from list B and C. All right. And technically, you can't tell people what they are to provide as their documents. Technically, you can't do that. Most people will say, let me see your driver's license and your social security card. Technically, you can't do that. All right. But so just give them the form and say, I need either one of these on list A or a list B and a list C. Okay. You don't have to make copies of the documents. If you do make copies of those backup documents, make them for everybody. All right. There are people who, for Hispanic employees, made copies of the documents, and for non-Hispanic employees did not. Make copies of everybody if you do, but you're not required to do that. And keep your I-9s in a separate file. Don't put them in the personnel file. If you don't put them in the personnel, and that's just a best practice. There are things called I-9 audits, and it's good to have them in a separate file. And so in the event that you have an I-9 audit, you can just pull the file out and hand it to the agent that's doing the I-9 audit, and they don't have to dig through your personnel files, because you don't want anyone digging through your personnel files except you. The Americans with Disabilities Act, this is again federal law, became law in 1990. Applies to employers with 15 or more employees, but it protects people with physical or mental impairment that limits one or more major life activity. It protects applicants and employees. It requires reasonable accommodation. And this is key. The person must be otherwise qualified to do the job. All right. So if a person is not qualified to do the job in other ways, the ADA doesn't require that you hire a person that's unqualified. All right. But if the person is otherwise qualified, then you need to look at, all right, is there an accommodation that we can make, and what's reasonable? Well, reasonable in one person's eye is unreasonable in another. So you have to look at it on a case-by-case basis and determine whether it's a reasonable accommodation or not. It limits the kind of medical information that you can receive from an applicant or employee. Focus interview questions on non-medical qualifications. But that being said, don't ignore the obvious. So for instance, I used to hire a lot of equipment operators, or was involved in hiring a lot of equipment operators. Well, if the person comes in and it's obvious they are going to, let's say a person is in a wheelchair, and they come in and they're going to have to go up a set of steps to get into a piece of equipment, then it's okay to have that conversation about, all right, you realize that you've got to get in that piece of equipment. Let's talk about that. All right. And in some cases, it may require an accommodation. And oftentimes that depends on expense. And again, it's on a situation on a case-by-case basis. So don't ignore the obvious, but don't dig. All right, until after an offer's been made. But after making a job offer, you can ask disability-related questions and conduct medical examinations. But again, if that person comes in a wheelchair and it's obvious that they're going to have to be climbing, then you can have that conversation. Keep personnel files and medical files separate. So I've already told you to keep your I-9s separate. Also, I would encourage you to keep your personnel files, personnel in one file and medical information in another file for each person. Family Medical Leave Act. I'll quickly go through this because I don't think anyone here has 50 or more employees, but it is federal law. You've got to have 50 or more employees within a 75-mile radius. An employee must be eligible. What does that mean? Well, they've got to work for 1,250 hours for you in the last year. All right. And it provides 12 weeks of unpaid leave for the birth or adoption of a child, placement with an adopted child with an employee, care for a parent, spouse, child with a serious health condition, or if the employee has a serious health condition. The reason I wanted to bring this up is some larger employers, of course, are required to do this, and some of them now are actually paying some of this leave, providing that. So that's kind of what you're up against in some cases when you try to hire folks. A couple of others I won't spend a lot of time on, but I thought everybody knows about the ACA, the Affordable Care Act, also known as Obamacare. It became law in 2010. There's a 50 employee threshold. It's very complicated, and it requires employers that meet that threshold to provide certain levels of coverage and certain levels of minimum coverage, and it can be expensive. And if you talk with folks that are involved in the benefits realm, it can be very expensive. But anyway, the Fair Credit Reporting Act, that probably would apply to you more so. And that became in 1970. The reason I'm just mentioning it in passing, it applies to motor vehicle reports. But if you use a vendor who does your motor vehicle reports for you, if you have to, and if you have people driving your vehicles, please do a motor vehicle report on them. Have an MVR done on them. And I encourage you to use a vendor that does that. It's not that expensive. And they make sure that they have all the documents in place, that they meet the requirements of the Fair Credit Reporting Act. All right, so they'll take care of all of that for you. So do that. I'd also have them do a drug screen if you have drivers. Do a drug screen as well. And again, the provider of, let's say, I say FCRA, your provider of your MVRs will help you with that. There is a law also, the USERRA is what I call it because it's long. It's Uniform Services Employment and Reemployment Act. That's of 1994. That came along shortly after the first Persian Gulf War. And some of you, I've been around longer than most of you, and I remember that. But people returning from military leave, they are to be allowed to return to work if they return within a certain period of time. There are some really good online resources available that can tell you about it. There's no minimum employer requirements, so it could apply to you if you have a veteran or a person that's in the military that needs time off. So again, this is one of these things that you look at and you go, well, what's what's the right thing to do? Well, we want to support people that are serving in the armed forces. So some newer developments. I thought I'd take just a couple of minutes before we go to questions. There sometimes employers will misclassify employees, and they will call them independent contractors. And they do that sometimes unwittingly, and they do that sometimes intentionally. And what I mean by that is if a person is an independent contractor, then you don't have to pay a Social Security match on them. They're their own boss, so to speak. And so there's some things related to employment that you don't have to deal with. But if you are telling them where to go and when and how to do things, there's a lot of rules relative to that, a lot of IRS guidelines that can help you understand if a person is really an independent contractor or if they're an employee. All right, so be careful. I think Walmart, don't quote me on that, but I think it was Walmart got in trouble not too many years ago because they were classifying certain employees as independent contractors, and they were really employees. So be sure an independent contractor is independent, is not your employee. And because there's a statute in place now that they can come after you more so than once they could relative to that. So be aware of that. Also, whistleblowers are protected, and we've already mentioned that in related to OSHA, but a whistleblower is somebody that raises their hand and brings up something that they think is a problem, and it creates a cause of action where if an employer discharges or disciplines or threatens, discriminates against or penalizes, retaliates against an employee for reporting a violation of federal law or state law, participating in a government investigation, hearing or inquiry, refusing to engage in criminal activity, and refusing employer's order to perform an act that would violate federal or state law. And that is in place to protect whistleblowers. And that's a private cause of action. So it's there. Sometimes people bring up things to management and management does nothing about it. My advice to all employees is go to your boss first. If you see a problem, go to your boss immediately. If safety issue or some sort of conduct issue, whatever, go to your boss first. Now, or go to your boss's boss. And but sometimes people don't feel like they're being heard. And sometimes these claims are bogus. I understand that. But sometimes people feel like they need to go to a governmental agency because they're not being heard at work. And sometimes they are designated whistleblowers because of that, and they are protected. So take care there. And this really probably doesn't apply to you, but I put it in here anyway. Non-compete agreements are becoming less and less fashionable. This is a Virginia law, and it applies to non-compete restrictive covenants. And it prohibits low-wage employees and certain independent contractors from being bound by a non-compete. What's a low-wage earner for this act? It's about $60,000 a year annually. And the law essentially says you can't, most non-compete agreements or most non-disclosure agreements, NDAs, cover three things. They allow us to protect our people, they allow us to protect our confidential and proprietary information, and then they also allow us to protect our business from competition. All right. This is carving out that competition piece where a former employee could go to a competitor. And some non-competes are pretty good and can be, they have to be pretty narrowly drawn, but they can protect your people for a period of time, meaning a person that leaves can't go after somebody and try to hire them. Likewise, a person that leaves can never use your proprietary information. That is generally protected forever, okay? But then likewise, it can, it also can keep certain people from competing against you for a period of time. This restricts that, the ability to compete. Or the ability to have this agreement to keep people from competing against you. So just keep that in mind. Any questions?
I don't see any on the chat box yet, Terry, but I had a couple questions. So earlier, well, let me do the most recent question that just popped up. So you spoke about the non-compete agreement ban. Does that apply for most of the contractors that you're speaking to here are Virginia based, but some of them are dual, and meaning that they can operate in the surrounding states as well. So with it, if they were to use a non-compete, or I guess I should put it the other way, say a contractor is actually living in Virginia, but their employer is in a neighboring state. Does that non-compete agreement ban apply to them, even if their employer is in a different state?
Christina, I don't know the answer to that. This is Virginia law. So it, and some of the advice that I got was you need to look at you need to do the analysis and with both states in mind before you can really answer that question.
Okay.
You see what I'm saying? So for today, then that's an awareness. You could actually, probably you could look that up, and it really just depends on, all right, we know we've got Virginia. All right, what's the other state, and determine that. And that's the advice that I got on that. I actually wasn't aware that had become law. And it looks like, I think it takes effect is for non-competes that went into effect after July 1st of 2020, I believe is what we, yeah, July 1st of 2020. So that would bear, and I might have some notes from that I could look into. And also, maybe we could talk about that a little bit next week.
Okay, that'd be great. And just to reiterate, that ban, that law is to protect the employee. It doesn't speak to the employer, correct?
Right, it's to protect, right, this law, and I get my tongue gets tied sometimes. This law protects employees, okay, or former employees. And so oftentimes, especially for executives, and well, it doesn't have to be an executive, but I've seen non-competes used throughout an organization. But oftentimes, if a person especially receives severance pay, they are asked to sign a non-compete or an agreement. Okay, and some call it an NDA, some call them non-competes, and oftentimes those agreements have the three components. That one, it keeps the person that's leaving from then pirating and stealing the folks that have left behind. So it protects people, and generally that's for a year, all right, or sometimes up to 2 years. And again, these things are very closely drawn from to even be legal. Okay, so that protects the people. It reiterates the protection of proprietary or confidential information, and that's the easiest thing to protect, because most even employee handbooks will have statements in them that talk about this. You may learn things in this job that's of proprietary nature. So protecting that confidential or proprietary information is generally the easiest thing to do. All right, as part of that agreement. But still, yet they will reiterate in that agreement, we've got confidential information and you're not to share that forever. And then the third thing is, and by the way, for the period of this severance, you can't go to work with a competitor of ours within a 50-mile radius of or whatever the terms are. And so that's the piece, that non-compete piece is the part of an agreement that's now being challenged, and that this law protects employees that are leaving a company from having to sign off on. And again, these agreements generally have to be very restrictive anyway before meaning in other words, a person couldn't write a non-compete for me and say, Terry, you can't go to work anywhere in the Commonwealth of Virginia. Well, that's not reasonable. So, they would have to draw it more. If I left an employer, you couldn't work for a construction company within certain area, that type of thing. And that's being frowned on, that non-compete. So it's to protect employees. Okay? That's a long way around to answer your questions, to protect employees.
Okay. And the other question that I had was from earlier. You had indicated at one point that it was not that it was not appropriate, but I know that there's some common practices that when companies accept applications, they'll also automatically just copy the driver's license. Is there anything indicating that that's not appropriate to do that, or?
If there's nothing that indicates it's not, other than I don't know why, it is driving. So, putting on my skeptical hat, is driving part of the job. Okay. And so, if driving is part of the job, then I think, you need to make sure that the person has a valid driver's license. And then making a copy of that would be reasonable to me. Where I've seen employers, Christina, have a problem with that is if a person doesn't have a driver's license and driving, it'd be nice if they could drive, because driving is 1% of the job, maybe. Well, that person really is, and the person's otherwise qualified, but they say it'd be nice if a person could drive. Then really, are you hurting yourself by excluding a person who doesn't have a driver's license but has dependable transportation? They live on a bus line or whatever. They'll be there every day. But are you really hurting yourself by saying, okay, I'm going to exclude this person because they can't drive, but driving is just really 1% of the job? And that's my caution on that.
That makes sense. Yeah, it's specific to this industry. Driving definitely is a
So,
service.
but for you guys, most I would think driving is pretty important for folks in the industry. And you've got small, you may have 2 or 3 people on a job, or maybe less. And you're out, you're working out where you're not on a bus line, that type of thing. So driving is going to be pretty important. So maybe the question is, do you have a dependable means of transportation? And talk about that, and make sure that the person can be on the job every day.
Well, and also the ability for them to drive a company vehicle to service the customer. That's where I think it comes more into play, of making sure that they can actually fulfill.
So I think clearly then making sure that having a valid driver's license is fine. And I think then in that case, I don't see anything wrong with making a copy of it, because it's really it's a job qualification.
Okay. All right. Very good. Thank you.
Does that make sense?
Yes. Thank you very much.
Sure. Anything else?
I don't see anything yet in the chat box, and no one's unmuted themselves yet.
Okay. Well, that's all I have. I hope it's been somewhat helpful, and I will see you next week.
Oh, excellent. Yeah, sounds great. Yes, very good information. Definitely eager to see part 2, so I appreciate it.
Very good.
Thank you, Terry. Thank you, everybody.
Take care. See you next week.